Day 4 of Monica's bad court thingy. This morning's proceedings open with an unexpected announcement from Monica. She would no longer be calling her boyfriend, Morgan Jonas, to give evidence on her behalf. No reason was given, that I could hear, so we can only speculate as to why. Justice Tran advised Monica that the failure to call Morgan to give evidence may give rise to a Jones versus Dunkel adverse inference. Ouch. What is Jones versus Dunkel? Jones versus Dunkel is a case concerning inferences that may be drawn when a party fails to call a witness or give evidence or tender documents, and that failure is unexplained. The failure may lead to an inference that the uncalled witness or evidence would not have assisted the party's case. It arises where a witness who would expected to have been called by a party, for example, because the witness can shed light or corroborate facts relied on by a party, is not called. At the conclusion of today's proceedings, counsel for the state of Victoria said she wanted to put Monica on notice she would be making submissions that Monica's failure to call Morgan should give rise to a Jones versus Dunkel inference. In addition, counsel said Monica's unexplained failure to also call her parents to give evidence would also be the subject of Jones versus Dunkel submissions. I was waiting for this, to be honest. The main witnesses to Monica's arrests were Morgan, her parents, and Victoria police officers. The key issue in the proceeding is whether the arresting officers had a reasonable belief that Monica was committing an offense. The state of Victoria will be calling members of the Victoria police force to give evidence. Monica is not calling her boyfriend or her parents, even though they were also present at her arrests. Concerned about the state of Victoria's flagged Jones versus Dunkel submissions, Monica asked whether she would have the chance to object to the state's submissions. Justice Tran informed Monica that it was a matter for her closing submissions as to why a Jones versus Dunkel inference should or shouldn't be drawn. Monica's one and only witness gave evidence today. Summary to follow. That means her case is closed, and she can't lead any new evidence or call any more witnesses. The state of Victoria can now open its case, that is, call witnesses in support of its case. Conscious of Monica's status as a self-represented litigant and conscious of the Jones versus Dunkel issues described above, Justice Tran asked Monica whether she would like the weekend to consider whether she wanted to call any other witnesses or lead any more evidence. Monica said,
"Yes, I will take the weekend."
Application to give evidence via audiovisual link.
Today's hearing also involved a hearing within a hearing. It was about an application by the state of Victoria for one of their witnesses to give her testimony via Zoom rather than attend in person. Before I summarize what happened, I need to provide some background to the application. For those watching the proceedings today, some of this background information relates to discussions that took place in court prior to today's hearing. As you know, I've been watching since day one. I haven't mentioned the state's application until now because nothing had been decided. So, prior to the start of the trial, the parties had exchanged lists of witnesses they were going to call to give evidence. The state of Victoria had a list of definite and maybe witnesses, all of whom were current or former police officers. Prior to the trial, there was a directions hearing about one of the witnesses on the state's maybe list, Ms. Wilson. Ms. Wilson is no longer a serving member of Victoria Police and now lives in Cairns. She wished to give her evidence via video link rather than attend in person. Monica did not agree, as she wanted to cross-examine Ms. Wilson in person. As a result, the state of Victoria had to seek leave for Ms. Wilson to give her evidence via video link. Leave of the court is required if the other side opposes an application to give evidence remotely. Leave was refused. On day 1 of the trial, Monica had decided she wanted to cross-examine all of the witnesses on the state's list and said she'd subpoena any witness the state didn't call. The state said they'd make all witnesses on the maybe list available so that Monica didn't have to subpoena them.
But if I subpoena them, then they will definitely attend. If I don't, then, as per what you've said about the witnesses being on your maybe list, they will only maybe attend.
Counsel for the state of Victoria assured Monica that the state would make all the witnesses available. Monica didn't seem convinced. Justice Tran explained to Monica that if Monica subpoenas the police officers, then that means they are her witnesses. You can't cross-examine your own witnesses without first having the witness declared as hostile, which is a separate process. Once this was explained to Monica, she was comfortable with the state's offer to call all the witnesses on their list. I can't remember whether this was on day 1 or another day of the trial, but counsel for the state of Victoria said they intended to file another application for Ms. Wilson to give her evidence via video link. New information had come to light. Ms. Wilson had a medical condition which prevented her from flying. To attend Monica's trial would require her to drive all the way from Cairns to Melbourne. Driving from Cairns to Melbourne would require her to take several days off work. Monica still did not consent to Ms. Wilson giving her evidence remotely.
She seems desperate not to want to attend, and that only makes me want to cross-examine her in person even more.
In support of the state's application, they said they would be tendering evidence of Miss Wilson's medical condition, but on a confidential basis, and on the condition the medical evidence was not provided to Monica. Miss Wilson had made it very clear that in no circumstances was her medical information to be shared with Monica. Justice Tran said she had concerns about hearing the state's application for Ms. Wilson to give evidence remotely if it meant she and the state would be privy to information about a witness that Monica was not privy to. In the context of the broader trial, it may be that Ms. Wilson's medical condition is relevant to issues of credit. As the presiding judge in the trial, Justice Tran will need to make findings about the credibility of all witnesses. It would not be fair to Monica if Justice Tran knows information about Ms. Wilson that could be relevant to her credibility, but Monica doesn't know that information. Ultimately, Justice Tran decided that in order to avoid any issues of perceived bias, another judge should hear the state's application. The application was heard today by Justice Pillay. Both parties made submissions about whether the state's application could be heard without the details of Ms. Wilson's medical condition being provided to Monica. Counsel said that if the court found that the information should be provided to Monica, the state would withdraw the medical certificate and wouldn't seek to rely on it in the application. Justice Pillay expressed concerns about the ability of Monica to respond to the application if she isn't provided with access to the medical information. Counsel said Monica knows that the medical issue prevents Ms. Wilson from flying. The only thing Monica doesn't know is the reason she can't fly. Further, Ms. Wilson isn't one of the state's witnesses. They've only agreed to call her so that Monica doesn't have to subpoena her. The issue in this case is whether the arresting officers had reasonable grounds to believe Monica was committing an offense. Ms. Wilson wasn't one of the arresting officers. Monica said that Ms. Wilson may not have been one of the arresting officers, but about 75% of the body cam footage from the day was from Ms. Wilson's body cam. She was present during conversations with the arresting officers that Monica wasn't privy to.
To properly cross-examine her, I need to be in the same room as her so I can observe her body language. I don't want to use the word lie, but I believe she lied and I want to prove that to the court. Plus, she seems very desperate not to attend in person. And I think that's an important factor.
After considering the arguments, Justice Pillay found in Monica's favor, for the state's application to be heard fairly, the medical information must be provided to Monica. Counsel for the State of Victoria.
Then, in those circumstances, Your Honour, my instructions are to withdraw the application. We will not be calling this witness. If Ms. Smit subpoenas her, then I understand the witness will instruct counsel to make a similar application to give evidence remotely.
Justice Pillay was not impressed.
Those submissions are very troubling. A relitigation of the same point that's just been argued in front of me. As soon as I've made my ruling, you're telling me there's going to be counsel here to argue the same point. How is that the efficient administration of justice?
My instructions are not to pursue the application if it will involve the disclosure of the witness's medical information. If she can't fly, she has to drive, which will require several days away from work. I apprehend the application will fail if I can't rely on reason why she has to drive.
This only angered Justice Pillay.
You're the ones who made arrangements with Ms. Smit to make this witness available. Now you're walking away from this arrangement halfway through the trial.
With respect, I am not walking away from this arrangement.
Counsel explained that all the witnesses still work for the state except for Ms. Wilson. What's happened is out of our control. Justice Pillay was not persuaded by counsel's explanation.
Before making the arrangement, there was no investigation done as to whether you could make these witnesses available.
Monica was loving this. As the application was no longer pressed, there was no application for Justice Pillay to decide. The matter was concluded. Justice Pillay left the court.
Subpoena of Miss Wilson.
Justice Tran returns, and the case continues. With the state no longer calling Ms. Wilson as a witness, Monica would now have to subpoena her if she wanted her to give evidence. Emboldened by Justice Pillet's judicial scolding of the state, Monica was keen to tell Justice Tran how difficult the state were being.
The agreement with the defendant has been completely disregarded. I have to pay $500 per day for her to be here. Ms. Wilson is a very important witness. The subpoena that I had previously drafted that the defense said was not necessary is now necessary.
Your Honour, I just want to put on record that we are not in breach of any agreement with Ms. Smit. We said we were in a position to facilitate the attendance of witnesses, but we are just unable to make one of the witnesses available physically.
In order for the hearing to finish by the end of next week, it would be necessary for Ms. Wilson to be subpoenaed to come to court on Wednesday. This meant Monica needed to apply for a short service order. Interstate subpoenas in the county court need to be served 14 days before the date the witness is required to attend. Justice Tran granted the order, so Ms. Wilson either needs to attend court on Wednesday next week or file an objection. Monica was very pleased with herself. But it later dawned on Monica that because she is the one subpoenaing the witness, she might need to pay for the witness to travel all the way from Cairns to Melbourne.
Can I ask, so who pays for travel and accommodation and everything?
Justice Tran explained that the person issuing the subpoena does.
Oh, can I make submissions about that?
Justice Tran explained of the requirements of a subpoena are that the person issuing it undertakes to pay conduct money to the recipient. Reasonable expenses of complying with the subpoena. Justice Tran also made clear to Monica that with today being Friday and the witness being required to come to Melbourne on Wednesday, Monica needs to serve the subpoena today, and she should do it during the lunch break. So what did Monica do during the lunch break? Well, she didn't serve the subpoena. Now, preparing this subpoena would have been pretty straightforward and hardly taken any time. It's a form, and all Monica had to do was insert the name and number of the proceeding, the witness's name, and the date she was required to come to court. Justice Tran also directed Monica to resources at the court who could help her if needed. But Monica's excuse wasn't that she found it difficult. Her excuse...
I got distracted, sorry.
Monica asked if she could do it at the conclusion of today's proceedings. Justice Tran had already explained to Monica that she needs to get the subpoena approved and stamped by the registry before she can email it to Ms. Wilson. It was lost on Monica that if she waited until 4:15 p.m., when the proceedings would conclude for the day, she risked running out of time before the registry closed at 4:30 p.m. Justice Tran adjourned the court for 20 minutes and told Monica she needed to go and file the subpoena right away.
Re-examination of Monica Smit.
Following Monica's cross-examination yesterday, it was now time for Monica's re-examination. The re-examination of a witness is where the party that called the witness asks the person further questions after they've been subjected to cross-examination. It's essentially trying to mitigate any damage done during cross-examination. The witness can only be questioned about matters that arose during cross-examination. As a self-represented litigant, Monica had to re-examine herself. Like with her examination in chief, Monica had prepared a series of questions to ask herself in an effort to ensure she didn't delve into making legal submissions. Again, I give credit to Monica for the way she's tried to balance the competing difficulties of being both a witness and an advocate, as well as the effort she's made to follow court procedures.
I've been warned that re-examination is not the time to make a speech, and as you know, I'm one to make a speech.
I mentioned that Monica had prepared a list of questions to ask herself. Unfortunately, she prepared a short list of very open-ended questions, and I don't think she'd given much thought to the answers she would give in response. No criticism of Monica in this regard either. She's a self-represented litigant, so could not know how to effectively conduct a re-examination. But by asking herself open-ended questions, this meant that the answers Monica gave were mostly irrelevant, unhelpful, and in many instances, incoherent. For example, one of the first questions she asked herself was about the doctor's appointment she made with her GP to request a mask exemption.
Is there anything you want to clarify about the doctor's appointment?
Was the question she put to herself. She then started ranting about what transpired at the appointment. She mentioned that the doctor wouldn't write her a mask exemption.
So I asked him if I can't get one here, where can I get one? He seemed really annoyed when I asked that, so he wrote me the letter.
By way of recap, The document that Monica produced as her mask exemption on the day of her arrest was a letter from her doctor that essentially said Monica believes she can't wear a mask. It wasn't a formal diagnosis.
So, did he write me the letter under duress? No, I don't believe so.
Oh dear. She then went on to testify that she believed the letter from her doctor was a proper exemption. To prepare for her re-examination, Monica read the transcript of her cross-examination. Except it seems that she completely misunderstood the point of some of the questions she was asked during cross-examination. In cross, video footage was played of Monica live streaming in her parents' car on the way to the protest at Treasury Gardens. Counsel put to Monica that the footage of her live stream was not journalism, it was Monica in the car with her boyfriend and parents having a chat. I didn't mention this in my summary from the other day, but during her cross-examination, counsel for the state of Victoria had also asked Monica some questions about why, when asked by police at Treasury Gardens to produce her driver's license, Monica was not able to produce it. I think the point of counsel's questions in that regard were to discredit Monica's purpose for being at the protest. If you were there as a journalist, you would have taken your driver's license, etc. During the course of Monica's re-examination, it became clear that Monica thought counsel were trying to pin her for driving without a license.
The defendants insinuated that I was driving and didn't have my physical driver's license and that I was driving illegally. Except that in the footage, I was clearly sitting in back seat. In the footage, you can clearly see I am not driving. I don't know why they thought I was driving.
This was so bizarre. Monica also addressed the CHO's directions.
If the CHO meant that only certain types of journalists could get a work permit, then he would have written that in the directions.
Technically submissions, but the judge and state of Victoria let it slide. In her re-examination, Monica also addressed accusations from the state that she was just an activist with a selfie stick. This next part was probably the peak of her incoherence. I tried to transcribe what Monica said, but she was all over the place with her response. So here's the gist of what she said.
The police just saw a snippet of a full story. They didn't know the full story. If anyone takes a tiny snippet of any event, it's important to get a full context before judging. If I see someone in the airport filming with a selfie stick, I would think, oh, another influencer. Without knowing more, I don't know why they're there, if they're reporting, if they're going home to edit the footage, if they have thousands of followers. They could be reporting about what is happening at the airport, even though they have a selfie stick. You can't judge if you don't know the full context.
Oh dear. Monica essentially agreeing with the state's defense here, which is that based on what Monica was doing on the day she was arrested, she appeared to be protesting. Monica also addressed the state's point that in the video footage at the time, she often used the term we when talking about the protest, including herself in the event. That is, if she was an independent journalist, she would refer to the protesters as they.
Well, there were also many times where I referred to protesters in the third person too. As many times as I referred to we, maybe they cancelled themselves out or something.
During cross-examination, counsel for the state of Victoria put to Monica that the fact she was planning to make a speech on the day meant she was there as a protester, not as a journalist. Monica said she didn't remember planning to make a speech, but was reluctant to admit that making a speech meant she was there to protest and not report on the event. In Monica's re-examination of herself, she seemingly admitted that she remembered she'd planned to make a speech, and not only that she agreed with the state's case that it was reasonable to assume that someone who was at an event to make a speech was a protester and not a journalist.
Even though I had planned to make a speech that day, I did not. It taught me a lesson. If you want to be a journalist and not get arrested, stay in your lane.
Oh boy.
Monica concluded her re-examination. Counsel for State of Victoria reminded Monica that at the end of her cross-examination yesterday, Monica had agreed to provide details of the politicians she'd said had stopped dealing with her as a result of her arrests today. Monica admitted today that there was only one politician, and she said she couldn't be sure that her arrest was the reason they'd stopped replying to her text messages.
Maybe he didn't like me trying to use his name to my advantage.
Monica's first and only witness.
Monica was now ready to call her first and only witness. She apologized to the court that she would be reading her questions off her phone.
I couldn't find a pen at lunchtime, so I wrote the questions down on my phone. Sorry, not very professional, but well, I'm not a lawyer, so...
Monica's witness was a man named James Wong. He was her videographer who she'd hired to film at Treasury Gardens on the day she was arrested, although he wasn't there when she was arrested the first time and was some distance away from Monica when she was arrested the second and third times, so his relevance as a witness was, pretty tenuous. In her examination of James, Monica performed better than I had expected. You're not allowed to ask leading questions of a witness during examination in chief, and I was expecting Monica to ask lots of leading questions. She only asked a few. From memory, I think on one occasion she realized she'd just asked a leading question and withdrew it before counsel for the state of Victoria could object. Despite this, her examination of James was a bit of a waste of time, as was the cross-examination. Monica had clearly called James to give evidence for her because she thought his evidence would help prove that she was a real journalist. Whether or not Monica was a journalist is not relevant to proving that she was falsely imprisoned. As mentioned, the key issue in this case is whether the arresting officers had reasonable grounds to believe that Monica was committing an offense. Monica asked James questions about his work and their professional relationship.
I paid you to take videos for RDA and edit them professionally, so that proves I was a serious independent journalist.
This was essentially the gist of where she was going with her questions. She tendered as evidence an invoice James had issued her for filming her at Treasury Gardens.
I would have paid that bill at $50 an hour, goodness gracious.
Leaving a bit out here.
It was an immaterial point, so didn't really matter, but showed not great attention to detail. Monica then proceeded to ask James about the day of the protest at Treasury Gardens. James had been running late and arrived just as Monica had been arrested for the second time.
When you arrived, what did you do?
I started shooting right away.
Monica, seemingly worried that shooting might be misinterpreted as James firing a gun at people.
For people who don't understand terminology, what do you mean by shooting?
During her cross-examination the day before, counsel for the state of Victoria had put to Monica that live streaming conversations with her parents and boyfriend in the car on the way to Treasury Gardens was not journalism, as it wasn't even newsworthy. Monica sought to challenge counsel's assertion by asking James his opinion about the newsworthiness of her arrests.
As someone who has done film work before, explain how newsworthy you thought what was happening to me.
Objection. The evidence so far is that Mr. Wong is a videographer and an editor. He's now being asked questions about the newsworthiness of something. There's no basis for this witness to be giving an opinion about that matter.
Justice Tran explained to Monica that she cannot ask James his opinion about the newsworthiness of an event until she first establishes that he has sufficient expertise to express an opinion. Monica asked if she could send a copy of James's CV later, but Justice Tran said she needed to provide the evidence now, as she needs to first establish James's expertise before she's allowed to ask him for his opinion.
How do I do that?
You could ask him questions.
Monica pauses, thinking what questions she would ask to establish James' expertise.
James, based on your experience in this field, would you consider yourself an expert in this field?
Objection.
Justice Tran upheld the objection.
There's no evidence this witness is an expert in the newsworthiness of an event.
James was arrested for breaching CHO directions for being in a group with more than 10 people. He had been with Monica just before she was arrested for the third time. He was part of the group of 25 people who were circled by police and prevented from leaving the area. When police gave the group the option to leave the circle, James did so, unlike Monica, who stayed in the circle in defiance of police directives.
In your not expert opinion, but your reasonable person opinion, explain if you think MSM journalists were treated differently to other independent journalists.
It was clear to me MSM were treated better.
Were you given the option to leave the circle peacefully and not get arrested?
Police never gave the option of not being arrested. They said you're all breaking the CHO's directives. They gave the option for media to leave without being arrested.
Monica wrapped up her examination by asking James whether he thought she was a real journalist.
I considered you were reporting like a journalist.
Like a journalist. Not a journalist, but like a journalist. I couldn't tell whether Monica was happy with that answer. Counsel for the state of Victoria then commenced his cross-examination, a different barrister this time. The cross-examination was a bit of a waste of time. Counsel tried to attack James's credit, but wasn't particularly successful in my opinion. Most of the evidence adduced during the cross-examination was barely relevant. One of the first questions counsel asked James was his understanding of what RDA did.
What did you understand RDA to be?
A social media platform, kind of like what my brother did.
Objection.
I think Monica didn't like what she thought James was going to say.
Objection. His opinion of what my organization did is not relevant.
Except Monica seemed to earlier imply that James's opinion about whether Monica is a real journalist is relevant.
I'm not asking for his opinion, I'm asking for Mr. Wong's understanding about the work Miss Smit did and the organization she was running.
He was my videographer, he wasn't my business advisor, he would have limited understanding of me and RDA.
Justice Tran reminded counsel that liability is going to turn on the reasonable belief of the arresting officers. She said that the relevance of this question was low, but in the context of questions Monica had put to James, she would allow it.
What did you understand RDA to do?
Like my brother's channel, inform people about things they didn't understand about what was happening with COVID and lockdowns. Yeah, more like did you know, and give people the information they didn't know.
Okay, so not journalism then.
The person making this video has cut a bit out here. A back and forth about work permits, which really didn't seem to achieve much of substance for anyone.
The most successful part of counsel's cross-examination was establishing that James wasn't there when Monica was arrested for the first time. When she was arrested the second and third times, James wasn't close enough to hear the exchanges between Monica and the arresting officers or hear the reason she was arrested. Counsel also sought to establish that James' real reason for being at Treasury Gardens was to protest, not to work.
You weren't there only to film Mr. Jonas's speech, you were there to join in on Mr. Jonas's protest, weren't you?
No, I was there to film. I wanted to get paid, sir.
You accept there's a distinction between recording a speech being given at a protest by someone who's an objective, independent cameraman versus recording for the purpose of editing to then distribute to promote the cause.
I don't agree.
Counsel then asked this rather odd question.
As well as recording what Mr. Jonas was saying, did you listen? When filming Mr. Jonas, did you turn your mind to whether you agreed with what he was saying?
Monica then rightfully objected, saying that James's political opinion wasn't relevant. At this point, it was nearly 4:15 p.m., the deadline Justice Tran had given counsel to finish his cross-examination. Monica then rose to commence her re-examination. I think she thought counsel had attacked James for his political views, so she spent most of her time trying to establish that there was nothing to be ashamed about for sharing her political views about lockdowns. Cross-examination. On Monday, the state of Victoria will call 2 witnesses, 2 of the most senior officers. Monica was a little worried about having to cross-examine 2
Big people.
on the same day, and asked if the state could call a small person instead.
A big person and a small person would be a lot easier for my brain, for my trial.
Counsel said no, and basically told Monica that it was a matter for the state as to which witnesses they wanted to call and when, and they would be calling 2 big people.